Arbitration, hosted by Rera Practitioners Welfare Association (RPWA). We are the bar association associated with Rera. The speaker for today is our very own committee member, Advocate Dr. Sanjay Chaturvedi, to give you a brief introduction and idea about how long Sanjay sir has been in the industry and what his experience is. Sanjay sir has been in the industry for more than 40 years and he's the second generation person in the industry. Erstwhile to him is the father, Mr. Murari Chaturvedi, was an expert in the field, and now Sanjay sir, since about 40 years, has been carrying on the legacy. And with that brief but humble introduction, I pass the baton to Sanjay sir to carry out the talk that he should.
Thank you, Vijay. President sir, Dinesh Vaidala, and my fellow committee members. Thank you very much for inviting me here for the very knowledge series seminar on Rera vis-a-vis arbitration, Rera Practitioners Welfare Association, and Rera MCHI jointly hosting the seminar today for the knowledge of people. Very burning topic, and Dinesh Bhai gave me this topic. In fact, there was no much literature or rulings were there, and good to see some research work. And let's see how the Rera and the arbitration law and acts are right now going hand in hand. What is that thin line between Rera and arbitration? What is the enforcement as far as the contracts are concerned, as far as the arbitration are concerned, or as far as the Rera is concerned? The topic emerged that whether if there is a agreement for sale which was executed much before Rera came in, and one of the clause in the agreement for sale is that the arbitration, that if in the event of any dispute between the parties to the agreement, whether the arbitration clause supersedes any other law, or whether at that time it was MOFA, or at that time now it is Rera, whether the person should go for Rera, whether the person should go to arbitration, whether it is compulsory for going into arbitration if the agreement for sale is either executed in MOFA or in Rera. So let's see what the law says and what the provisions are. The very first the definition. See, I am having right now 15 slides. Every slide I'll take 2 minutes. So it will take maybe 25 to 30 minutes, and then we'll have a question and answer session. And the slides are available with the association. You can always ask them the presentation. And for the question answer, let me complete the entire presentation, and then if need be, we can go for the question answer. And even after the presentation, you can send the question to the association. What is arbitration? Now, as far as the arbitration is concerned, the arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the disputes. Now, this is a very, you can say, simplicity definition, but arbitration is very, very, you can say, bilateral. No third party is involved in this. It is between you and me. When the party to the contract are party to the contract, I am absolutely certain on this, that party to the contract only can go as far as the arbitration is concerned. We'll see the Rera provisions also, that who are those aggrieved parties and what are those, who are the persons and who are the people, those who can come to Rera. Now, in the arbitration, one thing is certain, sir, that unless the parties agree to each other, the settlement between two parties, and then they know that okay, some third person maybe a court appointed or maybe a self-appointed arbitrator who gives and settle between the parties. We know that the courts are heavily burdened, and every court in India right now having some mediation center, some conciliation forums or something where the courts wants you to go for the arbitration, court wants you to go for the mediation, court wants you to settle it out of court, so that if there is a TV issues or some maybe a question of fact, you can always reconcile between in the arbitration. And when there is a question of fact, you can always have a certain agreement between the parties. I don't know this. Video vessel. Okay. Now this is what the arbitration was concerned. What are those provisions in Rera? The Rera is an act itself. It's an act which has been passed for a very specific purpose. If we read the preamble of Rera, why the Rera was enacted was that for two very specific purposes. One is that the Rera should let the transaction in real estate should have some transparency, and there has to be one regulator to regulate the entire industry. And this was actually the main object of Rera. Now, as far as the arbitration is concerned, I would like to, and when I am just comparing the Rera with arbitration, I would like to see these provisions of Rera. Now, what the provision of Rera says, as far as section 2 subsection ZG is person, there are some 8 type of persons are being defined under Rera: individual, HUF, company, firm, association, society, competent authority, and association of people. Now, Rera have very specifically defined these people or person for the purpose of section 31. Section 31 says who can come to Rera. People, those who are aggrieved, these are the person. The person who is is covered under section 2 subsection ZG are the person who are being covered for purpose of section 31, which very specifically says, the section says, any aggrieved person may file a complaint with the authority or the adjudicating officer, as the case may be, for the violation and contravention of the provision of this act or the rule and regulation made thereunder against any promoter, allottee, or real estate agent, as the case may be. Mind you, the word any violation or contravention of the provision of this act, that is Rera Act. But in arbitration, there is no specific act. The arbitration may cover it to be contract act, may it cover to be a transfer of property act, no, may it goes in arbitration, which basically have you can say module, a process to derive at a conciliation or at an amicable settlement between parties. But unlike IPC, unlike Rera, the arbitration is basically a open-ended forum for any disputes covered under any act for time being. But for just the criminality, but every act, the arbitration is covering the you can say any process of any act. But then in Rera, there is a very specific provision under section 31 you need to come. So there is a difference between arbitration and Rera. The arbitration is open-ended for all the acts, wherein the Rera is very specifically made for a specific purpose. And why I am saying so? Because there are some citations which I am going to cite as far as the Supreme Court is concerned. And as far as the very historical judgment which the Madras High Court has given very recently, 2021, and this is the line which has been defined in those judgments. And then if we are, clear with the very first slide, that what is the difference between arbitration and Rera. So we are clear what as far as the Rera is concerned, is for the specific purpose. It says that for a specific, if there is a default in the Rera, then it should come under section 31. And who can come? These are the people who can. Let's see. Next. Next. Next slide. Now, Rera provisions on dispute resolution. Now, this is Rera provision for dispute. We are having section 31, section 36, 30, 35, 36, 37, 38, 39, and 40. Now, these are the sections where very specifically Rera has provided, the lawmaker has provided that what are those powers of Rera authority. Arbitration Acts, yes, whether there is enforcement, yes, because it's an award given by the arbitrator. And there is a mechanism, of course, it can be challenged and it can be, further challenged. But the Rera were a very specific provisions on your screen, and I don't want to repeat this, that these are the power of Rera where the Rera can have its own jurisdiction, because Rera is a quasi-judicial forum. It is having a power to enforce the act which has been already enacted by the parliament. Can we go to next slide, please? I'm just rushing little because these are the sections you know already. So I am not going in detail on this slides. I will directly jump on those landmark rulings by the Supreme Court and the Madras High Court directly. So it will clear everybody's mind whether the arbitrator supersedes Rera or whether Rera supersedes arbitration, or whether both are going hand in hand, and people can have the question answered whether if there is a provision of arbitration in the contract as for agreement for sale, still whether the Rera is applicable. That's the question we are finding the answer here. Now, what section 79 says of Rera? Section 79, Rera says that it's part of jurisdiction. No civil court shall have jurisdiction to entertain any suit or proceedings in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. What the lawmakers were having in mind to insert this section in Rera Act was that whatever we are providing for, see, Rera is a very specialized act as far as the real estate is concerned, and just like Electricity Act or just like an insurance regulatory authority, just like a housing finance, we are having National Housing Bank, we are having so many other authorities which also have the quasi-judicial powers, and these are the powers given to Rera under section 79, that to adjudicate any conflict which is already addressed in the Rera Act. For say, for example, section 12, section 18, section 14 for deviation in amenities or your floor plan or whatever, and section 15 for change of hands as far as the promotion is concerned. And then it's not just section 12 or 18, it is also having regulatory powers, and if suppose you are not following the regulatory instructions of Rera, then it has powers to punish, prosecute. Next slide, please. We are having some citations. Now let's see. I am going back little older citations to the new citations. Now these are the citations which are very important. You and I have actually cited this particular matter so many times in so many cases when there is a possession date, or when the very specifically the honorable court has said that in the three years time is sufficient enough for us to to complete the project. And these were the citations. But this time I'm citing the citation for some other reason. This landmark judgment of either urban land and infrastructure, which has very specifically said that where it was held that remedies given to allottees of the flats are concurrent and they are in a position to avail remedies under the CPA, Consumer Protection Act, Rera, as well as the Insolvency and Bankruptcy Code of 2016. That means the prerogative is of the buyer or the aggrieved person, whether I can go to the consumer court, whether I can go to the IBC, whether I can go to the Rera. Now it is up to me, And even if it is more than that, I tell you, you can go even to the normal court also for specific performance in the contract. Now let's go ahead. One more citation. As far as the Vidya, Rera, and this particular citation is very important because this has been cited in so many other judgments also. Between the judgments, this is one of the judgments which the landmark judgment was actually delivered by the Honorable Supreme Court. It says that it is a settled law through judicial precedents that if the subject matter of a dispute forms part of a proceeding in rem, that is in rem, and then the same is not arbitrable. When there is very specific statement is being made by the Supreme Court. And I'm sure that we all know normal legal lingo, that what is in rem and in persona, then the same is not arbitrable. Hence, once an insolvency proceeding is commenced, it becomes non-arbitrable. Taking this ruling of the Supreme Court, Honorable Supreme Court, when very specifically it has said that it is not arbitrable. When, see, one person defaults, then he never say that I am in default. The arbitration is basically when you and I say, between you and I say that, okay, this is not according to me, and you say, no, it is not according to this, and let's go to an arbitrator who will give a better understanding of the contract which we have actually executed. And when both of us, by consent, goes to the court or arbitrator and then proceed further and you tell your side and I tell my side, and then the arbitrator decides. This is by consent. But when it is in rem, that other person who has defaulted will never say that I have defaulted. So only who will decide? Somebody has to adjudicate on this. That's the next slide. One maxim I would like to cite. The maxim is this: that it is a cardinal principle of law that a specific law regarding any subject matter has an overriding effect over any general law. Now, arbitration is a general law, I said, and there is a very specific law. Then what the maxim says, the principle is well and encapsulated under legal maxim, that is generalized, specificibus, non-derogant. That meaning that the provision of a general statute must yield to those of a specific one. So when there is a specific act, it is a maxim. So when there is a specific act for this particular purpose, where a regulator understands the industry well, a general understanding or general court may not be in a position to understand the intricacies of the trade. What is the carpet area, whether the balcony is included or not, whether there is a development agreement, whether right transfers from the landlord to the right transfer from landlord to the main purchasers, Now these are very specific and very you can say scientific way to generate those and transfer this. Sometimes those intricacies in the real estate are not understood by the general code, and that is why there is a problem. But when there is a specific authority who have expertise in the real estate, law and real estate transaction process, then they will be understanding the real estate very well, and that is why very specific law. The Rera is a very specific law with a very specific definitions under Section 2 in the Rera. What is the ruling? Let's see some rulings in the Gujarat Urja Vikas Nigam, the SR power 2008 code. This is a very important definition. It says that Arbitration Act has not been enacted for the specific purpose relating to dispute between real estate promoters and consumer, whereas RERA Act is enacted exclusively for the resolution and adjudication of dispute involving real estate promoters and allottees. Honorable Supreme Court in this on the issue raised whether any provision or dispute resolution between the licensee and generating company contained in the Electricity Act 2003 will prevail over the provision of the Arbitration Act, and that the provision of the Electricity Act are special and hence overriding the general provision of the Arbitration Act. So, in here, if I put instead of Electricity Act, I put Rera Act. Next slide. I'm little bit rushing this slide, but then I will go for a page that where Honorable Madras High Court has given a good review on that. Read that. Now, Honorable Supreme Court in the National Seats Corporations versus M. Madhusudan Reddy, after taking into consideration Section 8 of the Arbitration Act and the provision of the Consumer Protection Act, now in the Electricity Act, now this is the Consumer Protection Act. What does it say? That the Consumer Protection Act, the court held that since the remedy available under the Consumer Protection Act was in addition to and not in derogation. Now you read these lines. Section 88 of Rera, it says that in addition, Rera is in addition to and not in derogation with another act. The provision of any other law for the time being enforced, the complaint filed in the consumer forum would be maintainable despite there being an arbitration clause in the agreement to refer the dispute to an arbitrator. Now there is very clear ruling. Let's go another slide. Let's have some pondering. The point here is, it says that it is a well-settled position of the natural justice incorporated in the legal maxim, which I have already read for you. The later law, that is a recent law, always prevails on the other law. There is a question in the legal fraternity whether the MOFA is repealed or not. And if then it is not repealed, then why for one subject there are two acts? Why there is a Rera and why there is a MOFA? I'll just deviate little bit over here. See, as per the Indian Constitution, Article 256 says that whenever there are conflict between state and the central act, the central act will always prevail over the central. Now, Rera is a central act. MOFA is a state act. Just like MOFA, we have GOFA, we have KOFA, other Karnataka, Goa, all KOFA, Gujarat, Apartment Ownership Act. There are so many other acts which are the state-owned acts, just like MOFA. The Rera is a central act. Though we are having such a, you can say, legal framework, where the Rera has actually given power to state to formulate their own rules and regulations. Because the housing is a state subject, and every state is having a regulator called a Rera authority, and when you are having such very specific central act, then all those acts which have come very recently will prevail over on the other. Next slide, please. one overview that in one of the case, honorable member B.D. Kapat is now retired in Marera. In one of the matter, very specifically he has mentioned this in Rera. The honorable member had an opinion on this. Let's see what he opines on this. He says there is a presumption that the parliaments all the law enacted by it. The Arbitration and Coalition Act of 1996, whereas the Real Estate Regulation Development Act 2016 is the later enactment. By enacting the Real Estate Act, the Parliament has specifically provided in its Section 89 that the provision of the Real Estate Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time in force. So the provision of Rera had overriding effect over the provisions of Section 8 of Arbitration Act 1996. In view of this legal position, I have come to the conclusion that despite the arbitration agreement of parties, Rera gets the jurisdiction to adjudicate upon the dispute which relates to the subject of an arbitration agreement. Very specific. Let's go to the next slide. Now these are the rulings. Now next 2-3 slides, I'll take you to the ruling and the first. The ruling says that the Section 88 of Rera, which I have already told you, that it falls have in addition to and not in derogation with any other act for the time being in force, that it has actually zeal with the other act. And if it is so, the Supreme Court in the National Consumer Dispute Redressal Commission in DLF Limited versus Real Estate Private Limited of this is the citation, and again by the National Consumer Dispute Forum in this, and actually have very specific position taken by the Honorable Supreme Court, which says that after taking into consideration Section 8 of the Arbitration Act and the provisions of the Consumer Protection Act, the court held that since the remedy available under the Consumer Protection Act was in addition to and not in derogation of the provision of any other law for the time being in force, the complaint filed in the Consumer Forum would be maintainable despite the being an arbitration clause in the agreement to refer the dispute to the arbitration. Next slide, please. Last two. Now, this is the slide of the Madras High Court which I was talking about, and the citation. I think in the next slide I have taken. Yeah, it is in the next slide. So the Madras High Court has said very 2021, very specific one, and there is a very detailed version is on the net. You can always download this particular judgment, which I have not done it. So you can always go to the site and see what it says. In 4 points, the entire judgment I have actually on the slide here. I have said this, that what the Madras High Court said, that when cause of action and subject matter of dispute relates to action in them that do not pertain to subordinate rights in person. That means that if there is a right, who will say I am in default? I have to tell the court that sir, this is the default made by him, and I prove it on paper or with evidence on my own argument with all those rulings in the this. Only when it is not in person, so it is not in rem, it is in person, that the person who is actually guilty of somebody or something which is already maintained in the act, that is Rera. It has been defined already. That what if the position they have one position? Yes. Very, very specifically, the section 18 says that if there is an agreement for sale and the possession date at that particular designated possession date you have not given the possession, that means you are a default. And there is no ifs and buts. So when there is very specific provisions of Rera, then this particular observation of Madras High Court. The second observation I consider, when cause of actions and subject matter of the dispute affects third party rights, have other owners effects and requires centralized education, and mutual education would not be appropriate. So it is not enforceable. I go to a promoter and I say, you have actually defaulted, and the developer always has some, say, saying that for the force majeure, or maybe now it is COVID, and maybe some other reason, maybe the specific purpose that means maybe High Court has given some stay to the project, or SRA has given some project, they have that particular right to defend them. So who will decide that whether the particular thing has affected, not affected, whether it is right, it is wrong? There has to be somebody who enforce and listen to two parties. The third one is when the cause of action and subject matter of the dispute relates to inalienable civilian and public interest, functions of the state, and hence mutual adjudication would be unenforceable. I kill somebody and I go to the relative of that victim and say, ठीक है मैं आपको 5 लाख रुपया देता हूँ, छोड़ो मेरे ऊपर केस मत डालो. Can it be possible? No, because state is there and it says that now the state will be, you will be versus by the state. The state is going to prosecute you for whatever the crime you have made. So in public interest, when there is a fault, then it cannot be enforced or it is not arbitrary. And the fourth point it has taken, and the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per condition. So this is those 4 points which Madras High Court has taken. Next class I have given you this citation. So at the bottom of this slide, this is the citation which I have given. Army Welfare Housing versus Colonel R. Medicine. The judgment says that therefore considering now the 4 points the Honorable Madras High Court has already taken the view that what is not arbitrable. And now the Madras High Court says in the observation and in the operating part, it says therefore considering the nature of dispute involved in this case between the petitioners and the respondent that the arbitration agreement is an one-sided agreement giving no option to the respondent in the choice of appointment of arbitrator. The dispute involved in this case is covered under Real Estate Act. So it is Rera, very specific. It is not now talking about consumer or electricity or whatever. It has said that if it is Rera, then the statute provides special provisions for dealing with the dispute arises under the Act, and those remedies will not be granted by the arbitrator. This court is of the concerned view that the dispute between the parties in this case is not arbitrary. So very clearly, when he says that there is a arbitration clause in the agreement, and can it be mandatory for me to go specifically? Can the other party say that okay, we have already put it in the agreement that there is an arbitration clause, and even if today, say maybe I'm just talking two scenarios. One is before Rera and one is after Rera. If there is a before Rera, we know that okay, that but no Rera, now it is enforceable. All the MOFA agreement is enforceable in Rera. Yes. Why? Because of Section 18. Now, when you are having very specific provisions for this, can the parties insist that no, I don't want to go to the litigation, I would like to go for the arbitration? Can it be so? No. Under this rulings, now if an agreed person, whether it is a builder, suppose he has not got the money from the buyer, suppose those payments from the scheduled payments of construction if the developer is not getting, maybe the applicable tax is not getting. So can a developer go to Rera? Yes. He can say definitely, sir, he is not paying. I want to terminate him, and either you please make me get my money with interest, or maybe because Rera is not just for consumer, it is for the industry. And when it is so vice versa, because in section 19, even the builders have got the right to sue the allottees. There is a very specific provisions, yes. Now, after Rera, when the Rera is already came in, all those agreements which are enforceable in MOFA can also be enforced in Rera, and all the Rera agreement, those who are having still the arbitration, is just by choice, not by compulsion, that you can come and tell the parties that you must go to arbitration rather than courts. Next slide, please. Thank you very much. This is my presentation, and I'm open for questions if at all you are having it today, or maybe even after when you watch this video on various channels. You can always send me the questions. We are happy to the Data Practitioners Welfare Association. We are having professionals in the committee, and as a member, we definitely would like to help you all whatever questions you have. I just hand over to President Sir, Nilesh sir.
Thank you, Dr. Sanjay Chaturvedi, for such a enlightening session on Rera and arbitration. There has been a hue and cry between the Rera and allottees presently, which are facing this difficulty day in and out. And there is a rest put by the appellate tribunal. I'm just sharing the judgment where I believe I don't know how the encyclopedia of Dr. Sanjay Chaturvedi has missed this judgment.
No, I have read it one.
So I'm sharing on the screen. There is a judgment of the appellate tribunal bench of the Rera. It has, in sense, distinguished the two aspects, and my technical team will screen share it right away. I remember my old days when I started practice, and I was appearing in such a dispute where what are the things which can be arbitrated upon. Since it's a forum in personam and not in rem, the very simple aspect which I would like to share with my colleagues here. The disputes which are between private parties in a contract, there can be an arbitration clause and can be enforced. As far as a special statute is there, say a dispute between husband and wife cannot be arbitrated, it has a special forum called family. Of course, there can be conciliation there. If there is a dispute between landlord and a tenant, cannot be arbitrated upon, there is a special forum called small causes court, and there is a bar of jurisdiction in the Rent Act. If there is a dispute between a member and the society, it cannot be arbitrated upon, it goes to the cooperative. So on and so forth. If there is a dispute between a developer and a and there is a statutory remedy available. I repeat, statutory remedy, which is under a special act, that is the Rera Act. I am sure that the arbitrator cannot, in that sense, give remedy or relief under Rera Act. And it's a statutory relief available to both the parties, even a promoter or the allottee. The definition of aggrieved person is, it's a larger perspective. So aggrieved person under section 31 of the Rera Act can go to the Rera forum and seek remedies as available to him under this special statute. Now, coming back to this judgment, may I request?
Share it in the projector, but it is getting shared in the live with the other participants.
Is it possible? It's gone live.
citation.
Sharing. Sir, I have shared.
Yeah.
So this is a judgment in the appeal filed by one of the promoters, Mantri Dwellings Private Limited. The judgment is dated 11th July 2019. It is passed by full bench of the appellate tribunal. Now, going directly to the issue in hand, the para 11 of that judgment is very important. In that, it is referred to a clause of their agreement, which is arbitration clause. As per clause 59 of the registered agreement for sale, dispute differences between the parties regarding to any matter or connected with the agreement shall be resolved by arbitration subject to arbitration clause mentioned. Civil courts in Pune alone shall be the jurisdiction. This was the argument canvassed. And the appellate tribunal, full bench, has given a distinguishing factor and said, as per clause 60 of the agreement for sale, disputes regarding performance of respective obligations of the parties shall be adjudicated in civil courts at Pune. Clause 59 of the agreement for sale regarding arbitration pertains to dispute differences with regard to any matters relating to or connected to the agreement. It is having the Rera Act is a special act. It is having an overriding effect under section 89. Allottees have filed complaint under section 31 for refund of the amount and interest including compensation. Arbitration clause in the agreement for sale does not debar an allottee. I repeat, does not debar an allottee from agitating the statutory right for refund. And I repeat this again, that the word statutory, which I mentioned earlier, that it's a statutory relief which is given under a special act. And therefore, it cannot be said that complaints filed by allottees under Rera Act are not maintained. And it upheld the order of Rera granting relief to an allottee. And this is a full bench judgment of 2019. And it has put to rest all such disputes or differences which were coming from different forums. And therefore, it is now a settled law that Rera Act will prevail over that. And I request now Dr. Sanjay Chaturvedi to take up question and answers from the members present here. I don't know if we can take questions from the online members. We can. And if there are certain online questions, they can drop into the chat box or to our members in the WhatsApp group. We will try to take it.
So, any questions? Any questions?
Sir, one small question. Even though the citation is clear of the appellate tribunal that there is no bar in approaching Rera, sir, in your experience, what has been the approach of the Rera authority when this contention is raised by either the allottee or the promoter that either complaint should continue because it can continue or complaint should not continue because of the clause? So can you share your experience with the lower courts?
See, as far as my experience is concerned, of course, the Rera is a constitutional authority, and it has its own opinion, and they can have their own, interpretation of the law and all that. As far as my personal experience, I have never been such experience. But now, since the ruling is that the tribunal have already given a very clear-cut ruling, and we have the other rulings also of Honorable Supreme Court and Honorable Madras High Court also. So now the situation is absolutely clear that the arbitration cannot be the, you can say, compulsion if there is an agreement for sale and there is an arbitration clause there. Now it cannot be a compulsion for parties to not to approach it. they can always approach Rera, even though there is an arbitration clause in the.
Sir, another question. However, in the circumstance of situation where arbitration is initiated, say application is filed and parties have started participating, then what would the implication of that be? If the arbitration is initiated, if steps are taken for arbitration, then will there be a bar to approach Rera if arbitration is started?
See, when there is already a you cannot have a forum shopping. You can always stick to one forum. It is basically when somebody is already mediating you. As far as the legal authority is concerned, one should always check what is going on, because this is one of the form and one of the condition for data application also, as far as the complaint is concerned. Then we give all statement to data that we have not gone to any other forum and any other this. So it is better to either stick to the arbitration, or then to close the arbitration and go to it.
So there is one online question. I don't think it is relevant to this topic. If it is relevant, you can answer. There is a question asked by Mr. Arvind Joshi. It says that, sir, in Uttarakhand, is it applicable? Is Rera applicable to the rural areas? I am buying a piece of land in Haldwani in a colony situated in a rural area. Developer has not registered in Rera.
Absolutely. See, Rera is a central act, and in Uttarakhand is of course in India. So all the part of India is under this. Uttarakhand also having Rera, and one of the case which I fought in Dehradun, where the developer was developing a bungalow plot, and then sometimes it is not compulsory you to take a constructed area. You can either buy a plot also. So Rera very specifically have said either 8 units or more than 500 square meters. If you are selling, then you must take a Rera registration. Anything which is not there. So, and it very specifically says it is in planned areas. So now the various aspects of Rera is applicable, and in Maharashtra now there is two DCR. One is for Mumbai, one is for other than Mumbai. That is unified DCR. So every square inch in Maharashtra which is regulated. So if suppose that particular project is not regulated or not planned, then the Rera may not be applicable.
Any questions to the audience? Like first.
We'll definitely take your questions, even if suppose after you watch this video, so that we can always come back. We can write to the RPWA, become a member of RPWA, because this is a professional body which always goes on, enhancing the knowledge by mutual discussion and mutual, set up of deliberation in seminars on WhatsApp group. Whenever there is a landmark judgment comes, either in Rera or in tribunal or in high courts, then we usually discuss any circular, any government circular, any Rera circular which comes into the immediately in your WhatsApp group. So be in the group, and I believe that the membership of the IPW is right now open. Must have a membership for such professional group, and we are having Michil Sampath over here and Sunil also here. They'll tell us little more about the membership of the RPW.
The RPWA, it's a Rera Practitioners Welfare Association. It's an association of the members practicing in Rera. So members are advocates, CA, CS, ICWA, and then the developers are also members. So all the parties who are related to Rera are members of RPWA. Okay, so we have like monthly, we have two events which we talk about the current topic, which is very relatable about Rera. Then we have our WhatsApp groups in which we report the judgments, latest judgments by the authorities, which are very relevant and relatable to the persons who are practicing in Rera. Then we try to take up the issue faced by our members, like if a problem has been faced by any of the members. For example, if a developer is facing some problem in compliance, we take their view and we represent to the Maharera authorities. We also represent to the authorities the problem faced by our colleagues, fellow colleagues like CA advocates. If they are facing any problem in representing before a Rera authority, and how they need to be, we give our representation on behalf of our members to the Mahara. So we have like a live member, associate members. So I'll share the links with you all. So you all can please give your active participation.
Yes, I believe we conclude, and I request Mrs. Advocate Niti Lombat to the vote of thanks.
It is often said, especially in Mumbai, that land laws are so complicated that it is impossible to comply with all of them. You comply with one, you will find there is some other land law to comply with. We must sincerely thank Sanjay Chaturvedi sir for granting us his experience and his presence and his time, sharing his valuable knowledge on the topic of arbitration and Rera, and how there is interplay between arbitration and Rera, especially considering that both the statutes are meant for giving relief to the parties. So with that, sir, not only do we conclude the session, but we also invite memberships of the general public to the RPWA. We are a bridge between the bar and the bench. We are a bridge between the stakeholders, the promoters, advocates, CAs, engineers, etc., with the government authorities, with the Rera authorities, with the appellate tribunal, and with the courts to ensure that the land laws, at least in the state of Maharashtra, are complied with. And if there is any representation to be made that the land law in a so and so area, so and so district, municipality, locality needs to be dealt with in a particular specific or specialist way, we make representation to the government to help the recognition of the law in the area to area. So with that, let us conclude today's session, and we extend our heartfelt and sincere thanks to Sanjay Chaturvedi.